with his powerful brainwaves cradled in the warmth of reasoning. It's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Okay, so the most pervasive argument of all by those who want Kyle convicted, the people I call the anti-Kyles, is that he was a minor in possession of a rifle and he therefore could not claim self-defense. And the stipulation in the law that they're referring to is in section 939.48, and I'll read this for you. This is section 1M, subsection B, subsection B. The presumption described in paragraph AR does not apply if any of the following applies. Now, what's this presumption? And that is self-defense. So in other words, this is a law about self-defense, and there's a presumption that a person is acting in self-defense when certain things are present. We've gone through that a million times already, but one of them is a reasonable belief. There has to be an imminent threat, blah, blah, blah. Now, it says here, remember, we're talking about the presumption does not apply. The actor was engaged in a criminal activity or was using blah, blah, blah. So what does that mean? What they're saying here is that one cannot presume that they are acting in self-defense if they are committing a crime at the time in which they are acting. But the key word here is presumption. The law does not say that if a person is committing a crime that they lose their right to self-defense. What it says is that they might not be able to claim self-defense. In other words, the presumption that they were entitled to self-defense is no longer valid. Now you may think, well, that's crazy. I mean, you're misreading it. It clearly states here that if you're committing a crime, you cannot claim self-defense. Well, we'll blow that out of the water here shortly. What I wanted to do, though, was to find out, is there any case law about a minor in possession claiming self-defense? And I can't find much of anything. I did find an interesting case in California. If there is a state that's going to deny somebody their self-defense rights, it's California. Section 25105 states, Section 25100 does not apply whenever any of the following occurs. And this is concerning about giving a child a weapon, or let's say allowing a child access to a weapon, a firearm specifically. Okay, so let's go on down to subsection F, or element F. The child obtains and discharges the firearm in a lawful act of self-defense or defense of another person. Now, this is California law. I mean, obviously, Wisconsin doesn't have to abide this at all. But what they're saying is that you cannot be convicted of allowing a child to have a firearm if the child lawfully uses it to defend himself or herself. Well, how can that be if committing a crime negates your self-defense? So this is California law, but this ought to give you some pause as to whether you think that simply being too young to hold a rifle is going to negate your ability to use it to defend your life. Remember, this is California, again, about the most anti-self-defense state in the country. So let's take a look now to Wisconsin, after all. Okay, so again, I really had a hard time finding much of anything about a minor in possession of a firearm in Wisconsin that's relevant to what happened in Kenosha. So here we have jury instructions for felons claiming self-defense. Now remember, according to the anti-Kyles, if you are found to have committed a crime, you cannot claim self-defense. Let's read the jury instructions here. Now, this is for a person who is an ex-felon who uses a firearm in self-defense. And this is Wisconsin. It says, and this is what they're going to be told to the jury, The law allows a person convicted of a felony to possess a firearm under certain circumstances. Wait a minute. I thought there weren't going to be any circumstances. I thought that if you are committing a crime, you cannot claim self-defense. Well, a felon can't have a firearm. It's a felony. Serious crime. Now let's take a look at these elements. And it turns out that for this case here, Kyle would pass 4 of these 5 elements. Now keep in mind, you have to pass all 5, but that's a person claiming self-defense who used a firearm, and the crime that we're talking about is a felon in possession, a felony. It says here, number 1, the defendant reasonably believed that he or she was under an unlawful threat of imminent death or great bodily harm. That's standard self-defense. The defendant reasonably believed he or she had no alternative way to avoid the threatened harm other than by possessing a firearm. Now, that's not typical of self-defense in Wisconsin. However, for felons who want to be able to claim self-defense, this is an added stipulation. The defendant did not recklessly or negligently place himself, herself, in a situation in which it was probable that he or she would be forced to possess a firearm. And actually, Kyle passes this one as well. I know a lot of you anti-Kyles are going to say, are you kidding me? He should have known that by walking around with that rifle that he was going to be attacked. Read it carefully. It says the defendant did not recklessly or negligently place himself or herself in a situation in which it was probable that he or she would be forced to possess a firearm. No reasonable person can claim that Kyle walking around with a firearm made it a probable outcome that he was going to be attacked. After all, there were scores of people carrying firearms that night, and only one, Kyle, was attacked that night. And then stipulation 4, the defendant possessed the firearm only for the time necessary to prevent the threatened harm. By the way, there are 4 stipulations here, and I think I said 5 earlier. Okay, 4. Now, Kyle doesn't actually pass this one. Why? Well, there's no problem with him possessing the firearm after the shooting. He can't give up the gun. He can't just lay the gun down on the ground and walk away from it. That would be irresponsible. He has to maintain possession of that firearm. However, he was walking around with a firearm all night before the shooting. And so if he was an ex-felon and he ran into this problem with self-defense, then element 4 might not apply, in which case he could be convicted. But keep in mind something, this is really important. These are the jury instructions for somebody who is an ex-felon who possessed a firearm. In other words, he committed a felony and is claiming self-defense. Kyle, at best, committed a misdemeanor. And so the jury instructions are going to be looser than this. Now, the other thing to look at is the actual case law where this comes from. And this comes from State versus Coleman. I'm not going to go through the entire deal. In fact, I'm just going to tell you what's here. And in this situation here, we had a person who was inside his apartment and he heard people trying to get in. So he grabs a rifle and he waits by the door and these people bust in, but it's the cops. And he opens fire on the police. And he, I believe, killed one of them. So now he's in really big trouble because he was in possession of a firearm and he has been convicted of a prior felony. And so the state basically wants him convicted of this, and he appeals his case to the Wisconsin Supreme Court. They basically said that, well, there are extenuating circumstances around this case that made it okay for him to possess a firearm. Again, he won his appeal. Therefore, he could, in those circumstances, actually possess a firearm, which according to the anti-Kyles would be impossible. Okay, so I want to go back to the statutes, or I'm sorry, the jury instructions here and take a look. There's another thing I want to talk about. One is, according to the jury instructions, if these 4 elements are in place, then they must respond with a acquittal. It even says that at the bottom. If you are satisfied beyond a reasonable doubt that the defendant knowingly possessed a firearm, that the defendant had previously been convicted of a felony, and that the circumstances permitting the defendant to possess a firearm did not exist, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Now, kind of something that people tend to forget about. Appeals court decisions are drafted very narrowly. So in other words, when State versus Coleman was drafted, the state issued these 4 elements that it based its decision on. The Wisconsin court system put those into the jury instructions. However, it is quite possible that a felon in the future could meet only 3 of the 4. The jury would have to find him guilty, but the appeals court could come in and say that other one, in this circumstance, does not apply, and therefore they could actually loosen this restriction for that defendant. They can't tighten it. Okay, so again, this is for a felon, and Kyle actually passes 3 out of the 4 here, and on the 4th one, it's a little bit dubious. Now, there is another article that you should read if you're interested in this. It's called What to Know About Wisconsin's Open Carry Laws, Self-Defense, and More in Kenosha Protest Shootings. And one of the questions they ask down here is, could the suspect carry the rifle legally? And they go into some detail about minor possession and all that. But there's a quote down here that's rather interesting. Anthony Cotton, who is a defense attorney in Wisconsin who specializes in self-defense and any type of criminal defense, said whether or not Rittenhouse legally possessed the rifle is trifling compared to the homicide charges. Anthony Cotton is blowing this thing off completely. He's saying that, as far as he's concerned, whether or not Kyle was a minor possession is not even relevant. So I went and looked at his background. And if you look at his legal background, yeah, he knows what he's talking about. He understands Wisconsin self-defense laws very well. And it turns out that if there was any reason for Kyle to fear that being a minor in possession was going to jeopardize his self-defense claim, Anthony Cotton would have said so in that article. So this is part 1. I'm going to have more coming up. I'm going to be talking about felons in possession in other states that might give us some ideas about what can happen here in Wisconsin. Like my video and subscribe to my channel, and wait for part 2.